Thank you to Thomson Reuters for the introduction. I'll tell the audience a little bit more about myself here so that we can get underway. I am a New York City real estate attorney. I handle all matters dealing with real property law. I primarily practice here in Manhattan, in the city. And although I primarily focus on litigation, I also handle transactional matters, and I act as general counsel to many cooperatives and condominiums throughout the city. And as some of you may already know, condominiums and co-ops function just like corporations, right? They have boards that are responsible to transact the business for the buildings, and counsel, together with the managing agents, assist boards in that regard. And we'll discuss this a little bit further in the lecture, but there are legal terms of art that everybody should be aware of when dealing with condominiums and cooperatives, just so that we can flesh some things out as we get started here. In cooperatives, you have shareholders. There are actual physical share certificates, as well as proprietary leases. So in a cooperative, you're dealing with actual shareholders. It's synonymous with a corporation, a corporate entity. You have these owners who own the shares pertinent to their particular apartment. Okay. In condominiums, you have unit owners, and the legal terms of art for boards are board of directors, similar to, as you would have in a corporation for cooperatives. And in fact, cooperatives are owned by corporations. And in condominiums, you have what are called the board of managers. So again, just so we know at the outset, what we're dealing with here, the legal terms of art are extremely important when dealing with both cooperatives and condominiums. In cooperatives, you have shareholders and board of directors. In condominiums, you have unit owners and managers that run the board. Other than those legal terms of art, the cooperatives and the condominiums, as you'll see here, most of the law and the statutes on the books, whether it be the business corporation law or the case law, will hold that the legal aspects of both forms are pretty much synonymous with each other. What applies in a cooperative also applies in a condominium. For example, if you are seeking documents of a cooperative, and this happens all the time in New York City, and I see this particularly with respect to smaller cooperative buildings where you have a small board that's composed of long-time directors who have been running and operating the building for many years. Sometimes you have an entrenchment of power, and sometimes the board will refuse to give shareholders the documents that they're legally entitled to. So what you have to do under law is serve what's called a Business Corporation Law 624 demand, which is essentially an affidavit. Again, we'll look at this more particularly when we get more involved in the lecture, but you would serve an affidavit to demand certain books and records of the corporation, and those are specifically identified in the statutory language. And the board has a responsibility or an obligation to provide those documents, lest they be subject to statutory penalties or damages. So it happens all the time in New York. It's a big part of the practice, especially on the litigation side. And I do both. As I said, I act as general counsel for many boards and for co-ops and condominiums all over the city. And I love representing condominiums and co-ops because the legal work runs the gamut. Really, it's a full spectrum of what you can do and practice as a real estate attorney, right? There are so many issues to deal with, from evictions for non-payment cases to evictions based on objectionable conduct, which are called Pullman cases. They're called Pullman cases because of the famous Pullman, who was probably one of the worst tenant shareholders you could ever imagine. And that's how it got its name. Like a lot of areas of the law, they get their name from the cases, such as we have Yellowstone injunctions for commercial tenants in New York. For Pullman cases, the Pullman case law is based on this problem shareholder who was evicted from his apartment for objectionable conduct. Again, we'll look at that in full detail as we get into the lecture. But also probate matters, right? You have shareholders who pass away invariably, and their shares have to be appropriately transferred. And it's actually a big area of this particular area of the law, because boards have to be very careful when transferring shares to, let's say, a family member or somebody named in a will who is supposed to get the interests allocated to that particular apartment. And oftentimes, if the probate process does not run its course, a board can be subject to a lawsuit and damages from an heir that was appropriately supposed to get the interests of that particular property. So you can get into a whole host of problems if things are not done correctly. So everything has to be done procedurally with a board, and we always have to look at the Bible, the governing documents of the cooperative or the condominium, as the case may be. And we'll get into that here as we go along. But I'll get a call from a board or a board director saying, Massimo, we have a shareholder who suffers from dementia, and he damaged the basement area, and this really happened, by the way. He damaged the basement area where we keep our trash. He overturned the garbage and created destruction and all sorts of damages. So, what do I have to do? I have to write a cease and desist letter. You have to document the file and so forth. Or this morning, I was rendering an opinion based on what dueling language in the proprietary lease for a cooperative, how it would be dealt with. And you have to do research on what the provisions mean, if there are incongruities with particular provisions. This particular provision that I was dealing with this morning dealt with what the rights and obligations of a shareholder were to repair damages within an individual unit. So generally in New York, a shareholder has the obligation to repair everything within the four corners or four walls of their unit. Okay, let's say there's a fire, there's a casualty or a flood. That shareholder has the obligation at its cost, at its sole cost and expense, to repair everything within the unit. Now, when you start getting into leaks coming from the facade, for example, that are coming from the common elements, those typically are the obligation of the building to repair. Because again, remember, there are common elements. So what you have to do always when you're representing either a condominium or a cooperative is to make sure you look at the Bible, right? The Bible being your governing documents to determine what the rights and obligations of the unit owner are, and what the obligations of the cooperative or the condominium are, as the case may be, and how the common elements are delineated from and are separate and apart from the common elements or the elements inside the particular apartment or unit that fall on the shoulders of the unit owner in a condominium or a shareholder in a cooperative to cure. So those are extremely important points. And one of the major focus areas of today's lecture is going to be the Pullman case law, which I touched on a bit earlier. Okay, and we're going to be looking at that case, the Pullman case in particular, as well as its progeny, and some of the other case law. We're also going to be involved in looking at some of the drafting of the salient documents that I have been doing, and which you, if you're representing either cooperative or condominium boards, will need to be engaging in as a result of the COVID-19 pandemic. Okay, that's a big part of this lecture. We're going to be looking at the law that is needed to support those applications, both on the objectionable conduct side in terms of on the merits. But even before we get to the merits of an objectionable conduct Pullman claim, we're going to be talking about the drafting of protocols that have now become very important in a very different world that we live in because of COVID-19. And those protocols have to mirror and should mirror the governmental decrees. And that's true, depending on whatever state you're practicing in, but in particular in New York, with the government orders, the executive orders that have been issued by Cuomo, and there have been a string of them that some of them we're going to be taking a closer look at here. But those protocols will need to be adopted by your particular building, and I strongly urge you to do so if you have not already and you represent boards. And they should be posted in places in the common areas and the elevators where the residents can actually see them, and you can properly apprise them of notice of the protocols. And remember, keep in mind that the research and the instruction on how to handle in terms of disinfecting, sanitizing the viral matter from COVID-19 is changing really almost on a daily basis. And that has been true since the disease first hit our shores earlier this year. And we see it still changing daily. I think a few days ago, the World Health Organization did an about face and now is taking the position that everybody should be wearing masks, when they originally said that masks should only be worn by the infected and that they should not be used by everybody so that they could save and stockpile them for the medical health professionals that actually needed them. So, and the numbers are staggering. When I submitted these materials just about 2 weeks ago now, and you'll see, I believe it's my one of my first footnotes here. It's actually footnote 2 on page 1 of the lecture materials. I submitted these materials on May 24th, 2020. Okay, just a few weeks ago here. And as of that time, 342,000 people died. I just pulled up the most current statistics, and that figure has risen dramatically to 397 deaths. So within the span of a couple weeks, we have an additional 55,000 people that have died because of this disease. Okay? So the numbers are just staggering. The disease and its level of extreme virulence is unmatched. And it's been unprecedented, and it's created unprecedented aspects in the law as well. And there have been some good notes also. I read a news report yesterday out of New Zealand that they now have 0 active cases. That's incredible. They were very quick to act in New Zealand. They shut their borders down almost immediately. I think New York lagged a bit in terms of shutting things down, taking proper measures. If you walk around New York City today, you'll see most people wearing masks. You'll see most people taking the proper precautions. But that did not happen within the first 2 weeks of the virus coming to New York City. And it spread like wildfire. It spread on subways. It spread in the, on trains. And it really, really took over the city. And, we hope that in New York City, the COVID-19 infection and death, epicenter here is drastically reducing. There are reports from a few days ago saying that there were no deaths as a result of COVID, which was the first time that had happened since early March when the disease first hit our shores. But however, only time is going to tell if we're going to be hit with a second wave here. Many people believe that the recent protests in the 5 boroughs and all over the streets in New York City that have been going on for the better part of a week due to the social unrest following George Floyd's murder at the hands of 4 Minnesota policemen will cause the infection to increase dramatically again. And the problem with the disease is understanding it. It's so difficult to cope with because people can be asymptomatic for up to 14 days. You may not know that you have the disease for 14 days, and within that span, you can be infecting hundreds and thousands of people. So that's the problem. And the other thing is that the disease is constantly changing. There are constantly conflicting reports from the government, from the research community, right? First, it was 3 feet you had to stay away from somebody. Then it was 6 feet that you had to stay away. So, the fact of the matter is that the scientists don't really know how the disease is properly transmitted. And they just don't know. The science is changing daily. What we do know is how pernicious this disease really is. So without further ado, let's jump right into the lecture and talk about the pandemic a little further, because it's very important to understand the pandemic in terms of how to properly cope with it when drafting documentation and protocols for the buildings that you represent. So we're on page 1 of the lecture here, and the COVID-19 pandemic, I've listed it here. It's an unmitigated disaster. And I think that is a very apt title for the current disease. And the destruction in the wake of COVID-19, as we said earlier, it's been unprecedented. On the scale of pandemics, the novel coronavirus, which is called COVID-19, is ravaging the globe, and it continues to do so. Not only in terms of its virulence, but in economic destruction as well. And we're starting to see that, especially here in the States. Some big companies have filed for bankruptcy. J.Crew, I think, was the first major large company to file for bankruptcy. And there have been several others, and you'll see it'll be like the floodgates have opened. There'll be a string of bankruptcies that will be filed from these large companies. A lot of people think that the brick and mortar restaurants and mom and pop shops, especially here in New York City, are never going to open up again. So what the Chapter 11 bankruptcies, a lot of people think will do is that they will have a serious downscaling, especially on these national chains, shutting down a lot of their brick and mortar stores across the country, and that they're going to shift more towards a virtual platform on the internet and selling products via internet. Obviously, you can't do that if you're a restaurant, so that's why a lot of people think that restaurants are probably the worst of the bunch in terms of being able to recuperate from this. So again, there's still investigations going on here. We have tremendous conflicting reports, even regarding how COVID-19 came about. I mean, some experts say that the virus emerged from a seafood and poultry market out of Wuhan, China, as it was first reported in December of last year. But there are other reports, I think more so in the right wing Republican camp, that the pathogen was man-made in a Chinese lab in Wuhan and somehow got out. So there have been reports that Trump's administration sent people in to investigate. Those investigations have been inconclusive, and I think predominantly people believe that the virus certainly came from some sort of animal, a bat, that then made it into food, was ingested from this poultry market in Wuhan, and then ran its course. But the numbers are staggering. Again, look how many people have died. And this figure, as I told you before, this 342,000 people dead is not accurate. It's actually far more than this in the last 2 weeks since I submitted these materials. There's another 55,000 people that died. So that's a staggering figure, and it's increasing daily. In fact, according to the last reports that we got from the U.S. National Institute of Allergy and Infectious Diseases, there's going to be at least 200 to 240,000 Americans that are going to perish, and millions are going to be infected from this disease. So, and on March 12th, 2020, the World Health Organization announced the COVID-19 outbreak as a pandemic. Clearly, it is on the scale of pandemics, one of the worst that we have seen in our history. So, to date, 100,000 plus Americans have died, and most of them actually have been here in New York City, which is why New York City is the epicenter, and why it's so very important for condominiums and cooperatives to take the necessary precautions in terms of social distancing, in terms of sanitation, and disinfecting, right? Because those are the ways that we actually know that the disease spreads, right? It's sticking on handrails. It's sticking on the high-touch surfaces in your building, on the doorknobs, in the common areas, in the elevators, on the buttons, on the doorways and door handles, on the way in and out of the building. Okay, so you have to be fastidious about constantly cleaning, and you have to implement those particular precautions and instill them as protocols within your building so that they are properly run. So, again, while the scientists are working towards developing a vaccine or some drug to effectively combat COVID-19, the world leaders in the countries that have been impacted by the virus have enacted these strict governmental lockdowns. They've barred travel, they've closed the courts, blocked tourism, and employed social distancing measures to try to stop the spread. And finally, after several months here in New York City, it seems to be working, which is good news. We're gonna see if these recent protests caused by the social unrest have increased, will increase those numbers again. But only time will tell. We'll have to see. And what we've also seen here is, in addition to the human death toll, the economies have really suffered on a large scale. So in New York, Governor Andrew Cuomo issued a string of executive orders, and I have included in the footnote the government website that you can click on, and you can actually pull up every single order, every single government order, governor order that was enacted. And feel free to read those. Everybody should be familiar with those orders. They're extremely important. A lot of them are going to be litigated. There was an order that was, I believe, issued this morning that further extended the statute of limitations through July 6th. Okay, that order just came out, so you can click that and check it out. One interesting statistic here is footnote 4 is the Supreme Court of the U.S. on March 12th, 2020 announced an indefinite closure due to COVID-19. It was the first disease-related closure since 100 years ago, when we had the 1918 H1N1 virus. Okay, so, precedent setting here. And most of the other states have issued similar governmental decrees closing down businesses, which again has impacted the economy deleteriously. I also have in the footnotes some of the other states, California, Texas, Florida, and you can see that those orders closely mirror what Governor Cuomo did here in New York. So it's the first time in our history where every single state in the union, all 50 states, declared a state of emergency. And here's our first exhibit, Executive Order 202.10. If you open that up and take a look at it, it is a 4-page document. Take a look at page 4, and the very last paragraph is the pertinent provision that we're dealing with here. And it says, in pertinent part, non-essential gatherings of individuals of any size for any reason, for example, parties, celebrations, or other social events, are canceled or postponed at this time. Okay, and then if you look at the subsequent order, which was issued recently on Friday, May 22nd, 2020, Governor Cuomo issued Executive Order 202.33. That enlarged Executive Order 202.10, and specifically the ban on gathering, explicitly permitting gatherings of less than 10 people or more, insofar as social distancing protocols and cleaning and disinfection protocols required by the Department of Health are adhered to. And I've also included Executive Order 202.33 in the materials. It's Exhibit 2. If you take a look at that main body of the paragraph there on page 1, what I just cited to, and it was interesting here because the Governor Cuomo issued this order after the NYCLU, the ACLU sued the governor in federal court based on the separation of church and state, and based on the fact that religious institutions were given an unfair advantage over others and private individuals for being allowed to gather while others were excluded to. So, that was a big impetus behind this, why this was enacted. And again, similar business closures were adopted by other states across the country. We have massive job layoffs, an implosion of the healthcare system, debasing of the stock market. Most people think we're headed towards a recession. Obviously, the federal government had to provide stimulus. And on March 27, 2020, President Trump signed into law the Coronavirus Aid, Relief, and Economic Security Act, which everybody knows as the CARES Act. It's a $2 trillion emergency relief bill seeking to stimulate the devastation to the economy in the wake of COVID-19. So now we're going to take a look at some of the comparisons with the 1918 H1N1 virus. There's also a very good link here. It's footnote 8. And you can take a look at the there's some images from the 1918 flu, and the similarities between the two viruses, COVID-19 and the 1918 H1N1, are striking. And it's funny because the 1918 flu is often mischaracterized as a Spanish flu. And if you look at footnote 9 here, there was actually nothing Spanish about the contagious disease. It was all over Europe during World War II. I'm sorry, during World War I, but underreported due to military censorship, except for in Spain, where the coverage was unchecked. So that's why they call it the Spanish flu, but it was actually all over Europe. And it's going to be interesting to see how this all plays out. But what we do know is that there were similar precautions that were taken as a result of the 1918 flu that are being taken with respect to COVID in terms of social distancing, putting people who are sick in isolation and quarantine. And so we're getting now right into the drafting of the COVID-19 protocols for condominiums and cooperatives. And this is why it's so important to understand how the disease spreads, because if you don't understand the disease, and again, it's tough because the research is changing on a daily basis, but what we do know is social distancing. If you stay away from people, you'll stop the spread. And if you constantly clean and disinfect, you will ensure that the microbials that make people sick are not getting onto the high-touch surfaces and infecting people within buildings. So invariably, the coronavirus disease has led New York City condominiums and cooperatives to adopt rules and regulations regarding social distancing protocols and disinfecting and cleaning protocols pursuant to the governor's orders. And I was actually, footnote 13 is a Wall Street Journal article that I was quoted in early on in the disease when the COVID-19 first really reared its ugly head here in New York City. And I talked about the precautions that I was taking during those early stages. And I had seen a lot of the reports coming out of Italy. I had seen the videos. I saw how depressing and devastating the disease was. So I took the disease pretty seriously. And I stopped using the elevator in my building. In fact, I have not used the elevator since March 12th, 2020, because, again, there are reports that the microbials, when a sick person sneezes or coughs in an elevator, can stay suspended for a period of up to 30 minutes or longer. So if you're getting in an elevator, and you might not even know it, you can walk into an elevator 30 minutes after somebody else was in it and potentially get sick. The answer is we don't know yet, but it's possible. It's very possible. So, if you live, it's very difficult, because if you're in New York City and you live on the 23rd floor, it's impossible to take the stairs up and down. So what you have to do is wear one of these N95 masks The N95 mask is one of the only ones that has a filter and stops, the spread of breathing in the microbials if you're in a crowded place, or, for example, if you're in an elevator that has just been sneezed in by an infected person. The masks that everybody is wearing, is wearing now in public, as you see, are the surgeon masks or the cloth masks, which don't stop you from getting the virus. They curb the ability for you to give the virus if you're infected, but they do not help you from getting the virus. So, in fact, there have been many policies that are enacted by co-ops and condos throughout the city. I've helped them draft such protocols. And, some people, especially early on, I think in the media, were taking the position that these rules were draconian. They're turning the buildings into prisons and fortresses. In fact, I was also quoted in the New York Post in an article, in one such article. I'm a firm believer that these protocols are enacted to provide safety, to stop the disease from spreading, and that they're actually working. And after some time, they are now working, thankfully. So there are some buildings that have introduced tougher rules than others, obsessively sanitizing everything, including even the doormen, effectively creating moats to protect themselves from outsiders. And as you'll see, all boards are protected when adopting these policies. And so long the boards are adopting these policies based on informed decision making, based on the scientific reports, again, that are changing daily, but based on those reports that are before them, as well as the governor's orders. As long as boards are fashioning rational policies based on those things, it's nearly impossible for a court to overturn them. So call them draconian as you will, they will withstand judicial scrutiny. So again, the answer is still unknown. Scientists are scrambling to figure out how long the disease remains on surfaces. But what we are seeing are additional stringent policies that buildings are employing. And until we have more definitive research on the subject, particularly with regard to transmission and the life of the microbials that are spreading, the answer is an unknown. But here I've included a practice tip. When you're drafting these protocols, bear in mind that whatever policies are adopted, they should closely resemble, if not mirror, the effective extant governmental orders with regard to social distancing, disinfecting, cleaning, etc. And they should apply equally to everyone without exception. And I have italicized everyone equally here because not only when dealing with COVID, but when dealing with any legal issue with a condominium or a co-op, probably the most important thing that you need to realize as a practitioner is that all rules, whenever adopted, need to be applied equally across the board to everyone. Because then you are putting yourself in jeopardy of being hit with a discriminatory lawsuit. And that's the last thing you want as a board. Your directors and officers policy probably won't provide coverage. And just to stay above board and to ensure that you are having zero liability, those are the words of wisdom right there. Okay, apply all rules equally without exception to everyone. Okay, so the single most important guideline when drafting any governing documents is, and this is true whether we're in the time of COVID or not, is to ensure that they are universally applied. Right? You want to deflect against future discriminatory claims as we saw above. So, as in all other areas of the law, the appropriate legal terms of art need to be adhered to when drafting and litigating cases on behalf of condominiums and co-ops. And we touched on this a little earlier when we were opening the lecture. So another example here is that shareholders are the holders of the shares in the proprietary lease pertinent to their units, while unit owners hold the deed to their respective unit. Additionally, directors elected by shareholders populate the board of cooperatives, whereas managers elected by the unit owners populate the board of condominiums. So very important legal terms of art. I think as we started the lecture, we got into that, but it's very important, especially as a practitioner. And what's funny is the story I told you about earlier on what I was working on this morning. I was drafting a memorandum to a board of a cooperative on the ambiguity between two provisions in terms of an obligation of a shareholder to repair damages within their units. And the first thing that I saw in the proprietary lease was a reference to condominium. Okay, so the practitioner, who knows when they drafted the document, improperly interchanged a condominium with cooperative. So that's the one thing that jumped out at me right off the bat. And then obviously, you really have to watch out and make sure that you are properly implementing cooperative and the legal terms of art that are synonymous with cooperative and condominium, vice versa. So now we're getting into privacy considerations. One of the most important cases in cooperative and condominium jurisprudence is Lewandowski. Lewandowski versus 1 Fifth Avenue Apartment Corp., 75 NY 2D 530. It's a 1990 case out of the Court of Appeals. This is Exhibit 3 in your materials. It's at the end of your packet, Exhibit 3. The famous Judge K, Judith K, issued the opinion for the Court of Appeals. She's from the K. Scholler firm, very famous jurist. And the facts at issue in Lewandowski are not as important as the holding. But in Lewandowski, there was a shareholder of a cooperative. He started what's called an Article 78 proceeding seeking to overturn a board resolution, which directed him to restore a steam riser within his apartment to its original position. And why is Lewandowski so important? Lewandowski is so important because it came up with the business judgment rule. In Lewandowski, the Court of Appeals minted a judicially created rule known as the business judgment rule. I refer to it here as the BJR in the materials. And it was expanded to apply to the challenges of decisions made by a board of directors in the case of a residential cooperative corporation or board of managers in the case of a residential condominium. It also applies there. And in 1928, we look back to the famous Chief Justice Cardozo, who is next to Judith K., probably the single most important jurist out of the Court of Appeals, in the landmark Maynard v. Salmon case. That's 249 NY 458. That's a 1928 case from the All-Star Court of Appeals bench, probably the greatest Court of Appeals bench that New York has ever seen. And he explained the fiduciary duty in a case involving a joint venture. And I think the language that Chief Justice Cardozo employed are extremely instructive for our purposes. He writes, "A trustee is held to something stricter than the morals of the marketplace, not honesty alone, but the punctilio of an honor the most sensitive, is then the standard of behavior. As to this, there has developed a tradition that is unbending and inveterate. Uncompromising rigidity has been the attitude of courts of equity when petitioned to undermine the rule of undivided loyalty by the disintegrating erosion of particular exceptions. And he cites to Wendt v. Fisher. Only thus has the level of conduct for fiduciaries been kept at a level higher than that trodden by the crowd. It will not consciously be lowered by any judgment of this court. So very striking language here, and we see the great level that is required by a fiduciary to be exuded. And that case is also in Exhibit 4 of your materials. And the business judgment rule provides that so long as the corporation's directors have not breached their fiduciary obligation to the corporation, the exercise of their powers for the common and general interests of the corporation may not be questioned, although the results show that what they did was unwise or inexpedient. So again, this is a fundamental part of being on a board, that your decisions, insofar as they are made on informed consent, with all the documents before you relative to a particular subject, those decisions will be ironclad. They will be protected. So if we look further at the fiduciary duty, in the context of a co-op or a condo board, the duty arises from that special relationship between directors of co-ops and managers of condo boards, and the shareholders and unit owners respectively, who, as a consequence, place their trust in them. Okay, and where else do we see these fiduciary relationships in the law? We see them formed in relationships such as the lawyer-client relationship, broker-client, or the clergy-parishioner, for example. Okay, and that list is not exhaustive. But the fiduciary duty is closely analogous to the duties described in New York's Business Corporation Law, Section 717, and that states in relevant part as follows. A director shall perform his duties as a director, including his duties as a member of any committee of the board upon which he may serve, in good faith, and here's the kicker, and with that degree of care which an ordinarily prudent person in a like position would use under similar circumstances. In performing his duties, a director shall be entitled to rely on information, opinions, reports, or statements, including financial statements and other financial data. Okay, so if we look at the last part of what we just read, now you know what a board director or a board member can rely upon. And it's quite expansive, right? It's not extremely specific or explicit in terms of the documentation that's to be reviewed. It says opinions. An opinion can be anything. Okay, information. Information is a pretty expansive term. So make sure, as either a board director or a board member, you're relying on some particular document or information in connection with promulgating your protocols, whether they be COVID-19 protocols or a resolution for the day-to-day operation of the building. And as enunciated in Lewandowski, in light of the business judgment rule's early foundations and the changing world of commerce, the fiduciary principles identified in the existing case law, primarily emphasizing avoidance of self-dealing and financial self-aggrandizement, will of necessity be adapted over time. Emphasis applied, okay? So we have a continuing change of what boards can look at when making rules based on Lewandowski. And that's constantly changing over time as technology gets better. And in fact, one of the big points that I think we'll touch on here also in the notes is all boards now are going to have to look at implementing new policies for how they hold meetings. Because historically, they didn't have virtual platforms. They didn't have Zoom or BlueJeans or other virtual means for conducting meetings. So a lot of these governing documents need to change to be brought into current times in terms of allowing for meetings to take place by virtual means so that people can socially distance, because you can't be close to each other nowadays. So there's going to be a sea change in terms of the level of amendments that need to be made to these underlying documents going forward in order to account for the pandemic and for future viruses of this nature should they come about. This way we're better equipped to handle them, and buildings can properly and smoothly operate in the event of a major disaster like a pandemic in the future. All right, so although the levels of fiduciary duties are constantly expanding, originally breaches of the duty attached to those directors or managers that were held to the building funds in trust for the benefit of the shareholders or unit owners in the building. All right, so what does that mean? Hence, the duty requires a high degree of good faith as well as great confidence and trust upon the holder of the duty. The special bond of responsibility that board directors and managers have is conferred by the votes of their shareholders or unit owners at the building's annual meeting, who expect that those individuals voted to the board will advance the best interests of the community. Okay, so how does it work? Boards it's very political, right? Especially in cooperatives, small cooperatives where you have problems, as I had discussed earlier. If it's a 4-unit cooperative and all of the 3 out of the 4 unit owner or 3 out of the 4 shareholders are aligned with the board president who has been in that role for the last 20 years, guess what? Yeah, they're going to make that life of the 4th shareholder potentially miserable. And I've seen it happen. It happens all the time. Okay? So in the larger buildings, it's a little more democratic. You can run. You have a better chance of cracking a board that has been together for a long time if you can run a good campaign, if people like you, if you're sociable. So there's also a very big political element in boards. All right, so let's take a look at some of the particulars of the breach of the fiduciary duty. Okay, what do we have? We have the obvious one here, right? Self-dealing. You're stealing or embezzling money from the co-op or condo's reserve fund. And, although you don't see this a lot, it still happens. I have a case that I'm dealing with right now, in fact, that I am preparing a demand letter on, okay, where the board, a small co-op, absconded with some money that belonged to the building. All right. There's another one here as well. In a case that I'm currently litigating, I have an outgoing board director shareholder that sold their apartment and failed to pay the mandated flip tax. It deprived the co-op of the substantial funds that it was entitled to upon a sale under the governing documents. And it's explicitly set forth there. And this shareholder was actually a director and concocted a resolution doing away with the flip tax. Okay? Clearly improper. And it's no surprise that the lawyer that was hired by the insurance company is at the settlement table with me now. Okay, so what about when a board conspires to procure the rejection of a sale of a unit so that they could individually purchase the unit below market and then subsequently sell it for a profit? That's footnote 17. So that actually happened, and it still happens today. There are personal vendettas. I'm involved in a very, very contentious litigation right now in a small cooperative building on the Upper West Side of Manhattan, where the board is refusing to allow my clients to proceed with run-of-the-mill alterations and both parties' experts, the building's experts as well as my client's experts, have indicated that these are very, very simplistic alterations, and this case will probably go to trial, and it's very possible that it results in a finding of abuse of power and breach of fiduciary duty on the part of the board, because no legitimate reason exists for the denial of these alterations other than personal animus. All right. So, however, look at it conversely. Had the board had experts who indicated within reports, either written or otherwise, that the alterations would pose some structural issue, for example, or some detriment to the building, okay, then the board would probably have a legitimate leg to stand on, as we saw under Lewandowski and its progeny. Then you have your conflicted transactions. Okay, engaging a contractor or other professional that an individual board director or member has a connection with, or if they are remunerated for such work. So look at section 713 of the BCL. That's exhibit 5 on the lecture materials. If you want to pull that up, you can take a look at that. And the title is Interested Directors. And this is an obvious one, and one that is very, very, very common, actually. And as because of that, in September 2017, Governor Cuomo issued an amendment to BCL 727 regarding conflict of interest rules for boards. And that took effect in January of 2018. And that's exhibit 6 to the material. So you're going to want to be cognizant of that as well. And if you're representing either condominium or a cooperative, you want to apprise your client of section 727 and the requirements of section 727. All right, because specifically, a board has to annually disclose to apartment owners contracts and transactions between the board members and or the condo co-op within the annual report of any such transactions to the extent that there was a conflict. And they'll also have to furnish a copy of BCL 727. Okay. And here's another practice tip. Any board director or manager should always disclose their interest in the subject transaction and exclude themselves from voting on such transactions. So this is a big one, okay? And you should always counsel your clients appropriately. Always tell a board director or manager to have full disclosure, right? You don't want to be in a situation where, you don't know, you may have to tell them, you may not have to tell them. Put everything out on the table. You will save yourself a lot of grief in the future, and most likely stave off liability if you are upfront initially and you exclude yourself from voting. You are completely above board. So if you follow that, you'll stay out of trouble and steer clear of liability. Okay, so we have discriminatory enforcement here. I think we touched on this a little earlier. When a board shows favoritism or applies a rule or regulation in a discriminatory fashion, Okay, we have another practice tip here. So you want to ensure that at all times there is no selective enforcement and all rules are equally and consistently applied. If you remember one rule from today's lecture, this is it, okay? And this applies again, whether you're in a pandemic and when we're out of the pandemic. This is one that you need to always, always remember and adhere to. It will help you immensely. All right, so let's take a look at some of the liability for breaching the fiduciary duty. You can have substantial liability, either as a board director or manager for breaching that duty. And most directors and officers' liability insurance policies disclaim coverage for breaching fiduciary obligations. All right, what does that mean? That means that you don't have an insurance carrier coming in and defending you and paying your defense costs. That means you have to go out of pocket. In addition to being sued and facing potential liability, you have to pay your own independent lawyer to protect you in the litigation. All right, and there are generally punitive damages at stake, which courts do not shy away from, particularly in light of the level of moral turpitude at issue from a particular board director or board manager. All right, so let's get into some of the privacy and confidentiality considerations here during the COVID-19 pandemic. And here are some important ones. Can a board legally notify its shareholders or unit owners that a resident has tested positive for COVID-19? We don't have any definitive case law on this yet, but the simple answer is no, unless the directors or managers want to expose themselves to potential liability. We've also noted there in the footnote that the Health Insurance Portability and Accountability Act does not apply to co-ops or condos. Be that as it may, though, you want to ensure that there could be no such liability. And the only way to do that is to keep these COVID-19 positive test results private and confidential, right? So pursuant to the Americans with Disabilities Act, typically such things as flus and those other common conditions are those that last for less than 6 months that do not fall under the definition of a disability. And that's at 42 USC section 12102 subparagraph 1. All right, there may be certain complications related to COVID-19 that ultimately may kick it into that disability and covered under the ADA. But again, at an abundance of caution, due to medical and privacy, confidentiality considerations, it is strongly advisable not to release the positive test results. Okay? Steer clear of that. This does not mean that the board should not notify the Department of Health, as well as the Centers for Disease Control and Prevention. That you can do, and you probably should do that. What about disclosure of positive COVID-19 test results for a building's employees, such as the doorman, super, the porters of the building, the people who are running and helping your building run during the pandemic? All right, so despite the unknown surrounding the disease and the research and data, again, that seems to be changing almost daily, the private medical details of the building's employees should similarly be protected. Obviously, to the extent that an employee does test positive for COVID-19, they must be quarantined and cannot return to the building until they no longer have the disease, and any areas that they came into contact with should be cleaned and disinfected in accordance with the DOH guidelines. All right, and that's also consistent, as we saw before, with Governor Cuomo's orders. And that should be strictly adhered to. All right, what about moving for emergency injunctive relief against renegade shareholders? Let's jump right into that. Okay, there are some buildings that have a bad apple. You got the renegade resident who doesn't like to follow rules, persistently engages in nuisance type conduct, And that was true before the pandemic even hit. And now we're in the midst of a pandemic. And this particular resident is, by his actions or her actions, endangering the life and safety of fellow neighbors. All right, so we have the infamous Pullman case. I touched on that in the opening of the lecture. Okay, let's take a look at that case. It's also in your materials. And I've also included the Kennedy case, which is a really good discussion on the differences between evicting a shareholder based on a board vote versus a shareholder meeting. So the infamous Pullman, all right, the facts in 40 West 67th Street Corp versus Pullman were as follows. Shortly after moving in, Pullman engaged in a course of behavior that, in the view of the co-op, began as demanding, but thereafter grew increasingly disruptive and ultimately became intolerable. All right, what did he do? Pullman started complaining about his elderly upstairs neighbors. One was a retired college professor, and his wife, who had occupied the apartment above his for over 2 decades. So Pullman sent the board 16 letters in the month of October 1999 alone, accusing his elderly upstairs neighbors of playing their television set and stereo at high volumes late into the night, and claimed that they were running a loud and illegal bookbinding business in their apartment. Pullman further alleged that the old couple stored toxic chemicals in their apartment for use in their dangerous and illegal business. And so the board conducted an investigation, and it found that the couple did not possess a television set or stereo. There was no evidence of a bookbinding business or any other type of illegal or illicit enterprise. And the hostilities between Pullman and the elderly couple continued to escalate, resulting ultimately in a physical altercation. And after the altercation, Pullman distributed flyers to the co-op's residents. He referred to the professor by name. He said he was a psychopath in our midst and accused him of cutting defendant's telephone lines. In another flyer, Pullman described the professor's wife and the wife of the board president as having close, intimate, personal relations. He also claimed that the previous occupants of his apartment revealed that his upstairs neighbors have historically made excessive noise. Additionally, Pullman, it turns out, made alterations to his own apartment without board approval, had construction work performed on the weekend in violation of house rules, and would not respond to multiple board requests to correct these conditions or to allow a mutual inspection of his apartment and the upstairs apartment belonging to the elderly couple. Finally, Pullman commenced 4 lawsuits against the upstairs couple, the president of the co-op, and the co-op's managing agent, and tried to commence 3 more. Having had enough, the co-op called a special meeting in accordance with Pullman's proprietary lease, which provided for termination of the tenancy if by a 2/3 vote, the co-op determined that because of objectionable conduct on the part of Pullman, the tenancy of the lessee is undesirable. And that's the pertinent language there, right? Objectionable conduct. Conduct that is viewed objectively by an outsider as being reasonably intolerable or improper. So the co-op notified Pullman as to the date, time, and place of the meeting, that its purpose was to determine whether Pullman engaged in repeated actions inimical to co-op living and objectionable to the corporation and the stockholders that make his continued tenancy undesirable. And look at the numbers. The numbers don't lie. By a vote of 2,048 shares to 0, the shareholders passed a resolution finding Pullman's actions objectionable. Despite this, Pullman still refused to leave. So the co-op was forced to bring a lawsuit against him for declaratory judgment. declaring that his stock and lease were canceled and for ejectment alongside attorney's fees and costs. And the holding actually, it was a divided court of appeals. It was not a unanimous ruling. And the court ruled that Lewandowski prohibited judicial scrutiny of actions of co-op boards taken in good faith and in the exercise of honest judgment in the lawful and legitimate furtherance of corporate purposes. The dissent, on the other hand, believed that the co-op should be forced to prove Pullman's objectionable conduct prior to being evicted in light of the fact that property is sui generis, meaning that it's unique, and that there are typically great protections under the law vis-a-vis an individual's home. And as the Pullman court enunciated, the very concept of cooperative living entails a voluntary shared control over rules, maintenance, and the composition of the community. Indeed, as we observed in Lewandowski, a shareholder tenant voluntarily agrees to submit to the authority of a cooperative board, and consequently, the board may significantly restrict the bundle of rights a property owner normally enjoys. So this ruling was really earth-shattering. It was the first time that the court ruled that a board could kick out an owner from his home. And it was based on this objectionable conduct. Now, the majority said that the board doesn't need to prove that the conduct was objectionable. There's no other proof that's required since the shareholders voted, right? All of the members of the community where Pullman was living and together residing with wanted him gone. And that's enough for the court. The court doesn't need to get into whether or not the conduct alleged was objectionable. They will rely on the shareholders. And, one of the important points in these types of cases is ensuring the malefactor, the Pullman, as in this case, giving him the opportunity to be presented by his accusers. So whenever I'm doing these Pullman cases, I will always set forth in detail, in the way of a letter, usually several letters, documenting all of the objectionable aspects of the behavior of that particular shareholder. And then once there is a vote that's going to be scheduled, as the case may be, I will invite the shareholder and give him or her adequate and proper notice under the governing documents so that he or she can be presented with the accusers and can respond to the actions that are alleged, the egregious actions that are alleged. And typically at that meeting, I will also have a court reporter so that a transcript can be prepared, fully documenting in a writing what transpired at that meeting and all the back and forth. All right, so in order for co-ops and condos to ensure the life safety of the residents and employees during the COVID-19 pandemic, they may need to seek emergency injunctive relief against renegade shareholders like Pullman. I ended up obtaining the first reported emergency injunction in New York City, temporarily and preliminarily enjoining a renegade shareholder from continuing to violate the co-op's COVID-19 protocols, as well as the governor's orders against public gatherings, and made international news in the process. That's on footnote 22 there. You can take a look at some of the articles that came out. I was on CBS News. I was in the New York Post. I was in the English papers, New Zealand. So it was a big deal because this particular shareholder, like Pullman, was engaging in egregious conduct. But unlike Pullman, it was far worse. He was putting everybody's lives in jeopardy, okay? Through his conduct. He was sneaking people in through the elevator of the building so that he could have parties. Although there are no reported cases yet, a violator of a building's COVID-19 protocols may be subject to a Pullman action. So here's a practice tip. Remember that the courts view objectionable conduct under an objective lens as opposed to a subjective one. Let's get into some drafting. First, all co-ops and condos should have formal written COVID-19 protocols, as I said earlier in my lecture. And if not, they should have them drafted, preferably, of course, by counsel, as soon as possible. I have included a sample COVID-19 building protocol that I crafted for one of my buildings. That is Exhibit 8 in the lecture materials. Feel free to take a look at that for your benefit. All right, once the protocols are completed, they should be distributed to all building residents by management and posted in conspicuous places within the common areas, as I mentioned before, elevators, bulletin boards if you have them in the lobby, etc. And again, that's true with respect to all protocols that are adopted in co-ops and condominiums. You want to put them where people can see them, so that they can be properly apprised and put on notice of any new rules and regs. Here's another practice tip. Everyone is still quarantined at home. It looks like, although businesses, there's a staggering of openings of businesses starting today, and that will increase as we go forward here. Everyone, for the most part, is still quarantined at home, given the shelter-in-place orders. So it's a great time now to update your building's archaic governing documents. Bring them into current times by allowing for virtual board meetings, by allowing for virtual annual meetings, etc. In the event that a shareholder or unit owner violates the building's COVID-19 protocols, it may ultimately become necessary to do what I did and to commence an emergency action to curb such violations so that you can promote the interests of health and welfare and life safety of your building community. I've included here for your edification a sample summons complaint along with an emergency order to show cause application with supporting papers, seeking a temporary restraining order to preliminarily and temporarily enjoin, this one's for a shareholder, but to enjoin a shareholder from violating a cooperative's COVID-19 protocols. That's Exhibit 9 in your materials. All right, and that's tailored off of the the injunction that I was issued, which was the first of its kind in the state of New York. And let's look at some of the critical law for getting that injunctive relief. How do you obtain it? You have to meet the standards set forth under CPLR 6301. All right, and 6301 says that a preliminary injunction may be granted in any action where it appears that the defendant threatens or is about to or is doing or procuring or suffering to be done an act in violation of the plaintiff's rights respecting the subject of the action, intending to render the judgment ineffectual, or in any action where the plaintiff has demanded and would be entitled to a judgment restraining the defendant from the commission or continuance of an act. And that's what we have here, right? The plaintiff has demanded and would be entitled to a judgment restraining the defendant from the commission or continuance of an act. And it goes on, which if committed or continued during the pendency of the action would produce injury to the plaintiff. A temporary restraining order may be granted pending a hearing for a preliminary injunction where it appears that immediate and irreparable injury, loss, or damage will result unless the defendant is restrained before the hearing can be held. So you see there is a dual part analysis and it's a bifurcated process. First, and you'll see this in the papers, but first you have to move for what's called a temporary restraining order, and you do it by way of order to show cause. And first, initially, you get, or if you're able to prove to the court that you meet these particular factors, you can get an order to show cause with a temporary restraining order, meaning that the other side, before they're able to even put in papers, is bound by a temporary restraining order. And the court will generally put down the hearing on the preliminary injunction, which is the full injunction, pretty close out in proximity of time, to allow the other side to oppose it, to put in papers, at which point the matter will be fully briefed, and then the court will ultimately adjudicate whether or not the party is entitled to get continuing injunctive relief. Okay, so there are different standards to be met. The salient cases, some of them are here. You have Nobu Next Door, LLC. I've included that as Exhibit 10 in your notes. This is one of the most oft-cited cases on the standards for the grant of injunctive relief. And the holding there, as you can see in the case, it is well settled that in order to obtain preliminary injunctive relief, the party seeking a preliminary injunction must demonstrate a probability of success on the merits, danger of irreparable injury in the absence of an injunction, and a balance of equities in its favor. Okay, so those are the salient elements that need to be satisfied in order to be granted preliminary injunctive relief. And if you look at the papers, the sample papers that I've included as Exhibit 9, and particularly in the memo, you will see that there are specific subsections delineating each of these particular elements and showing why they have been satisfied. And if you want to get injunctive relief, you will have to do the same when tailoring your papers. So you want to pay particular attention and specific detail to these particular aspects in order to get this relief, because it is hard to get at times, depending on what the facts are. All right, so the language of the governing documents prevails. New York law is crystal clear on that, right? When parties set down their agreement in a clear, complete document, their writing should, as a rule, be enforced according to its terms. And these considerations are all the more compelling in the context of real property transactions, where commercial certainty is a paramount concern, and where the instrument was negotiated between sophisticated counsel, business, people negotiating at arm's length. This is WWW Associates, Inc. v. Giancon Carey. That's Exhibit 11 in your materials. That's, again, one of the most often cited cases in terms of plain meaning and contractual plain meaning. Also Vermont Teddy Bear, I've cited too. And accordingly, contracts are interpreted according to their plain and natural meaning. Mercury Bay Boating Club versus San Diego Yacht Club. There's also been a fairly recent case coming out of the Court of Appeals. That's 159 MP Corp versus Redbridge Bedford LLC. I've included that as Exhibit 12 in your materials. I suggest you all take a look at that. It's a very, very well-written case. One of the quotes here is, "In keeping with New York's status as the preeminent commercial center in the United States, if not the world, our courts have long deemed the enforcement of commercial contracts according to the terms adopted by the parties to be a pillar of the common law." So what does that mean? So unless the contract is entered into under duress, involves some illegal activity, or is contrary to public policy, freedom of contract prevails in an arm's length transaction between sophisticated parties. And in the absence of countervailing public policy concerns, there is no reason to relieve them of the consequences of their bargain. What does that mean? Okay, that means that parties can contract pretty much anything, so long as it's not illegal or contrary to public policy. Now, what's funny is that in this particular case, in the Redbridge case, that dealt specifically with whether or not two commercial parties contracting with each other could waive what is called a Yellowstone injunction. And although the Court of Appeals in Redbridge said, yes, parties can agree to that because it's not illegal, they're making a choice to waive a Yellowstone injunction. The legislature subsequently enacted a law and said that it is void as contrary to public policy. Okay, so that portion of Redbridge was effectively overturned by the legislature, but Redbridge still is still very, very good law on holding that parties can contract for pretty much anything. All right, so therefore, as counsel for the board of either a co-op or a condo, whether you're seeking to pulmonize or an emergency injunction to enjoin residents from violating your COVID-19 protocols, you first always have to look to the building's governing documents, right? So, for example, if we're looking to pulmonize somebody, first determine whether an objectionable conduct provision can be found. Generally, you have them. Sometimes you don't, though. And if you don't have an objectionable conduct provision, you are out of luck, or you may be out of luck, unless you can find some other clever way. But if you don't have one, I would strongly recommend that you talk to your boards about amending the proprietary lease to include one. And then once that decision's made, then you have to look to your Bible and see how to do that. What's the procedure? Do we need a shareholder vote? Do we need a board vote? Okay. And what are the thresholds? Do you need a 2/3 of the shareholders? What are the notice requirements? Right? So you have to also look at the procedure. You need 14 days notice to give to all the shareholders. Right? You don't want to go so far into this process where you're expending a tremendous amount on legal fees and investing copious time into accomplishing these things and then it turns out that you didn't follow a proper procedural step and everything is all for naught. So that's why it's critical to ensure that you are acting within the proper procedural posture. In some buildings, it's nearly impossible to accomplish any business by shareholder vote, particularly if the building has a lot of units, right? Most residents own their units as a pied-à-terre, etc. Then it's very difficult. Now is the perfect time to do it because everybody's home. So really, if you are counsel to condos and co-ops, you want to do that now. You want to see who's home. You want to go through your governing documents, see what portions need to be updated, and advise your boards about updating and how to update them. Make those recommendations now and do it virtually while everybody's home and is around so that you can accomplish it. All right, so although COVID-19 is still relatively nascent, we have seen and we know that the destruction that it has caused to human life and our economy has been on scales that are unprecedented. Moreover, it's already begun to open the floodgates of litigation with respect to condos and co-ops, right? You saw it in my case. You're seeing it daily, especially as there's this fight between rules, what can be promulgated, what can't be by boards in connection with COVID. You have some First Amendment issues that have arisen more recently in terms of whether people can protest in terms of these civil unrest, things that we have going on now. So throughout our history, catastrophic events have led to litigation. It's ultimately helped shape new laws, new legal doctrines. COVID-19 will be no different. And these catastrophic events are no doubt going to lead to legal modifications within the co-op condo realm. They already have. They will continue to do so. All we can do is continue to follow them, see how things shape out, and how the law develops. And so it's a very interesting time to be at the helm of stewarding a co-op and condo through this pandemic and seeing the ship through. And certainly I think we can see the light at the end of the tunnel. And I think we have come to our time here. I want to thank you all very much. I hope that everybody continues to stay safe and healthy during these unprecedented times. It was a great pleasure. And I'm now going to sign off. I don't see any questions that are in the course questionnaire forum. So I will be signing off at this time. Again, thank you, everybody, and stay safe.